Good morning, everyone. We'll get this meeting started in just 1 minute. There we are. Good morning, everyone. We'll make sure everybody's in the meeting. Okay, I'll just a couple of the rules on the meeting today. We want the working group members to have their video on. They'll also have access to the microphone, and if they want to speak, they will raise their hand and get into the queue to speak and address the working group. For public members, you will have an opportunity at the end of the meeting if you would like to speak. If you go down to the reactions button, please raise your hand during that public forum time, and you will be recognized to address the working group. So at this time, our other coordinator, Olivia, did you have anything that you wanted to address?
Nope. Folks should have received all of the research that I was able to do, all of the changes, the documentation, etc. Yeah, if there's anything else that folks need, please let me know.
Okay. So at this time, we had some subgroup meetings last week. What we'd like to do with that is have a short report on some of the work that those groups did. The first report will be from, is that going to be from Stacy?
Yes. Stacy's muted.
Yep, we're trying to.
Right. Excuse me. Hi, thank you. Good morning, everybody. So we have 3 of the subgroups: requirements, crimes, and methods. As I'm looking over our notes from our last meeting, I am seeing some overlap, so we'll probably hear that as we report back. But that's not surprising because of the way the requirements and the consequences of the statute just are so interwoven together. So the requirements subgroup, our charge is to look at what are the requirements that are placed on registrants, including any extension of time for the registration period, and then any collateral consequences that flow as a result of being required to register. So we've been talking about what requirements are placed on registrants if there's a failure to fulfill their registration requirements. And we're just starting to understand that a little bit more. We're trying to look at and understand the extension of the 10-year registration period if there's a conviction that results in incarceration of any crime. So we're looking at that and understanding that more. we're looking at and thinking about for that piece on the 10-year extension for conviction and incarceration. What sorts of crimes? Is it any crime that results in incarceration? And then the 10-year period sets after they're released? Or do we care about, a certain class of crimes as something that should trigger the 10-year reset? So we're looking at that. We're looking at, and Angie is doing a survey of other statutes that reference the registry and have some connection to the registry in terms of collateral consequences, whether it be licensure. I think licensure is probably actually not in play, because I think if a person is required to register, I think that usually is a disqualifier for most things. But we are looking at to see where the statute is referenced in other statutes. So that's, Angie's got a handle on that for now. And we will report back on what we know there. We also started to talk about something that was really in the methods subgroup domain, about whether there's a process to get off. And I think that conversation organically came about because we're looking at the extension of time for the registry. Logically speaking, when can a person get off? So those are sorts of things that we're looking at now. And I'm happy to take any questions, or we can just move on to the next subgroup.
Representative O'Neill.
Thank you. I just have a quick question. I don't recall talking about this, but when you talked about which crimes trigger the extension, did we talk about if they were charged with a related crime, like a sex crime or other crime that's currently required to register or continue to register, versus that they were convicted of that crime? Did we talk about that distinction of what they were charged with and what they were actually convicted of?
I think that was part of the crime subgroup,
Okay. 'Cause I think
Yeah,
which I'm going to summarize.
I just think that's a really important distinction, because that's obviously fairly commonplace for people to plead down.
yeah, and that's directly in the crime. That's directly in the crime subgroup. So
Thanks.
And the survey of statutes that Stacy talked about, I'm about maybe halfway through, and I'm going to get it done into that subgroup before next week's meeting on that. It shouldn't take too much longer to complete. I just got waylaid by many different things after I started working on it on Monday. So we did, I'm summarizing the crime subgroup, and that we talked about, we started out talking, and I think spent a fair amount of time talking about juvenile offenses. Should juveniles be required to register at all? Should they be completely eliminated, or should they be made to register maybe for only serious juvenile crimes, which I think the language from the group last year kind of focused more on that aspect of it. Should there be limitations on juveniles' time on the registry, and should juveniles' time be treated, or time requirements on the registry be treated differently from adults? And then we talked about, and this I think Representative O'Neill brought up, we talked about the same set of circumstances language in the statute and the requirement for registration under those, under any same set of circumstances. And that applies to any of the charged offenses in the statute. We talked about whether that should be eliminated altogether. Should that same set of circumstances be eliminated for certain crimes? One of the examples that came up, and I may have even brought it up, I can't remember, but false imprisonment, that was used as an example of a crime that gets a lot of people registered because it's charged a lot in like domestic assault situations. It's charged a lot in like maybe a regular robbery situation, things like that. So then often, most of the time, people plead to something other than the false imprisonment and the registration requirement applies. So that's just one example of a situation that impacts a lot of people. And then we just talked in general, you know, what crimes should be included, and the crimes that have been included to date. Why were they included in the first place? Was that based on research? Was that based on particular cases and policy? I think when we talked about the history, it seems like a lot of it's based on kind of things that happen, cases that happen, and then something gets added or changed on the registry because of that. We talked about whether the registration obligation should be part of the sentencing, or there should be some kind of a hearing on whether somebody's required to register in same set of circumstances cases. One of the members talked about that it can sometimes be a surprise or make people feel they can't really have plea negotiations if down the road they're told they have to register based on the same set of circumstances case. We talked about, I brought up, I think that my concerns with it being part of sentencing beyond what it already is, which is a notification, because of the collateral consequences. I mean, it is a collateral consequence, it's not a part of the sentencing. So not that there couldn't be a court process, I just brought up the concern about being part of sentencing versus a notification that they have to comply with cases or comply with the statute. And the court does already have that obligation under the statute to notify someone of the registration obligation, but that does not always happen. And it certainly, I think it happens less in same set of circumstances cases. We talked about if there would be a way to get more data or some data on same set of circumstances cases, and that's something that the BCA is looking into. If there's anything they can get us, that would be helpful on that. We talked about it becoming a predatory offender registry versus a sex offender registry, and if that's something, you know, that's good or not, or helpful or not. And then we just had asked Olivia to send out some information on the statute and the parts that we were addressing. And I think that's pretty much what we covered in that group. Any questions?
Seeing none, we can move to Sheriff Heck.
Hi, good morning. So in the method subgroup, we talked about primarily how registration applies to those subject to registration, and in particular under same set of circumstances, and how it was possible, sorry about that, how it's possible to get off the registry. A lot of these topics cross-pollinate across the various subgroups, so there'll be a little bit of repetition here. But when we talked about the discussion of the registry, there was comments made that the inclusion on the registry is currently strictly an administrative process. So when a person is convicted of a crime, that crime is evaluated to see if it meets the statutory requirements to be on the registry, and that determination is made by staff at the BCA who have a level of expertise in this. There were suggestions that perhaps this could be changed from an administrative decision to a judicial decision, and the committee talked about the merits and perhaps the pitfalls of that. The perhaps merits of that involved it being a judicial process, and it's being decided upon by a judge in a court. And some of the concerns voiced about that was, right now it's being decided by one particular group of folks that have a level of expertise in this, applying this law. And if it's now spread across the state to judges who had a varying level of expertise and familiarity with it, there's concerns about whether that would raise issues of fairness and consistency. Along the fairness and consistency thought there was also concerns about what this would mean if it were a judicial process for those who have a public defender versus those who could afford their own counsel, whether or not there would be disparate incomes based on that factor. We had some discussion about the same set of circumstances, and again, Marion, how that's applied and whether or not there's an appeals process to get off of registry, period. There were some folks voicing a thought that there should be some type of review, perhaps a judicial review that would allow those on the registry to make their case for why they should no longer be included on the registry. And there was some discussion around that, and it was brought up that there are currently some appeal processes available to those on the registry to get removed. We had continued discussion like many groups about the desire to have more data and the difficulty in gathering that data. There was also talk about the value of the registry, with members of law enforcement indicating that in their roles, the registry is used regularly, particularly when you're talking about failure to register cases or talking about investigating new crimes. We also had some discussion about the appropriateness of including juveniles on the registry, and particularly in light of what the recidivism rates are concerning some studies that were brought up. We also talked about potentially commissioning a in-depth study. So actually having someone go in with a legislative charge and authority to go and look at this data more extensively to come up with answers to some of these data questions that we have. I think that's about the gist of what we talked about. So if there's any questions, I'd be happy to entertain those.
Any questions there? Again, if you did want to make a comment, use the reactions button at the bottom and raise your hand. Just one comment about those subgroups that I think some of the members found interesting was that the first one started a little slower. It got a little more in depth, and by the third subgroup, there was a lot of detailed discussion, and I think it was described as digging deep. So, Representative O'Neill.
Thank you. I'm wondering if Angela could just talk just a little bit here about some of the processes that are available through the courts now, because I know she looked at some court cases throughout the years, and that was of high interest. And Stacy wasn't in that group; she was in court, and so she may want to hear that too. But I think it's important either here or back in the subgroup to really talk a little bit more about avenues that are currently in law to do kind of like that off ramp, that petition to get off of it.
So I think that I had just talked about in the cases that I've seen. So people have challenged it at the time of conviction. So for like in a same set of circumstances case, as part of that case, people have had the court or asked the court on motion to decide if the same set of circumstances applied. On appeal from those cases, I've seen it raised. I've seen it raised in risk level appeal cases, because to assign a risk level, somebody has to be required to register. So I've seen people raise it when they appeal the risk level. They say they shouldn't have even assigned it to me in the first place because I shouldn't, I'm not required to register. I've seen it raised in failure to register cases because, again, you have to prove that somebody is required to register. So they will raise it before the judge in failure to register case, saying they shouldn't have failed to register. They're not guilty of failing to register because they shouldn't have had to register in the first place. So it's been, and then the main thing that I see personally is people raising it in Section 1983 civil cases where they say that their registration is illegal, either unconstitutionally, or they usually bring into those statutory claims on whether the statute applies to them in the first place, whether it's some kind of problem that the statute applies to them. So those are the different ways I've seen it raised without an official process in place to raise those things.
Okay, Stacy.
Yeah, and I'll just piggyback on Angie's comments in response to your question, Representative O'Neill. Just to be clear, there's not an off-ramp, so to speak, for getting off the registry. Once you're required to register, the 10 years is the 10 years. And so just to draw that distinction between, you know, if I challenge whether I'm supposed to register, that's a different challenge than what we're proposing or we're talking about, and that we drafted language for coming out of the CSC working group, which is I'm doing all the right things. I'm following all the rules. I'm checking all the boxes. And I should be given the chance to come off the registry because I am showing that I am capable of that, you know, that I'm, you know, that I can integrate, that we want people to integrate into, you know, society and be fully accepted. So it's more like akin to an expungement. That's what we looked at. So I just want to make sure that everyone here understands the difference between a legal challenge that Angie was talking about, whether it's in 1983 or a same set of circumstances. This wasn't the same set of circumstances. Those are legal challenges about whether the person should register or be required to register. They're not an avenue of relief for the registrant to say, I'm doing all the right things and I've done everything that you've required me to do. I should be allowed to come off. You know, whatever that point is, whatever that time point is that we could, you know, conceive. So I just want to draw that distinction, make sure we all understand the difference.
Okay, Janine.
I was curious, as folks are in the different subcommittees having conversations about possibly permitting or shortening permitting to get off or shortening the 10 years. Above and beyond, Stacy, the individuals like compliance or success, are people looking at or considering recidivism rates for the type of behavior that got them on? Particularly with sex offenders, we have a pretty good body of research now to do down and dirty risk assessments. I didn't know if that was part of any of the conversations for any of the subcommittees where that came up.
Well, I mean, to some extent, I mean, it's come up just in the context of kind of whether the registry's meeting its purpose, if its purpose is to deal solely with recidivism, which there have been different things that have been said about the purpose. I mean, I think the main thing that's been said is it's for law enforcement, you know, purposes and solving crimes and things like that. Part of the risk assessment issue, you know, is kind of off of our, I mean, that's 244052, that's off of what we're looking at, but it certainly comes into it because that's where people get risk assessments. And I think that data is important to know just from the standpoint of if we think it's meeting its purpose, if we think one of its purposes is to reduce recidivism by having this data, then it certainly doesn't hurt to have that information. We talked about having some people come in and talk about recidivism, both with respect to the data and kind of some of the things you talked about at the seminar last week with respect to the dynamic factors and projective factors and things that you look at beyond the data because it's not, as we know, the data is limited by time frames and numbers and all that. And there's a lot more that you look at when you do a risk assessment than just the straight percentages. So we did talk about having, and you or somebody from MSOP might be good for that presentation, but having someone talk about that.
Sheriff Heck.
So I was in 2 of the subgroups last week. I don't recall which one this did come up in, but yeah, to answer your question, there was some discussion in one of those subgroups I attended that a risk assessment would be a good tool, maybe in considering who should or should not be on the registry.
Brian,
Yeah, just kind of what Sheriff Hack and some others have stated. We did discuss that possibility. I think I brought up sort of our current reassessment process for individuals that are assigned to level 2 or 3 from community notification risk level. And there's a certain period of time and criteria they need to meet. And then we're evaluated based on dynamic risk factors and other whole, looking at the whole case to go before another ECRC. Oftentimes the risk levels are lowered in those cases. So again, we didn't get into the details about that specific process and the resources needed, but it was brought up that that would be a possible avenue to go to sort of this off-ramp from registration situation.
Brian, you mentioned the end of confinement review committee. For just people who might not know what that is, can you explain what that is and the purpose?
Sure. So end of confinement review committee, or ECRC is the acronym. I'll state that now since it's a mouthful. Just say the whole thing all the time, is our process for assigning community notification risk levels for individuals required to register that are released from confinement, typically one of the state prisons. There's some other factors that come in there too, but for our ECRCs, there's a committee of 5 members. One of the psychologists in my unit writes a risk assessment recommendation report recommending a 1, 2, or 3. They go to that 5-member committee. The registrant individual can come in and represent themselves. They can, if they can afford legal counsel, bring an attorney in as well. But they have the opportunity to state their case. The committee members ask them questions, and then they leave the room. We discuss the case and vote on to assign the risk level, and that's the risk level that's assigned in that case. So just real quick, short snapshot of the ECRC process. But any questions, I can answer more of those if people need more details.
Representative Moeller.
Thanks. I just had a question about process. I'm really excited about all the ideas and the brainstorming that the groups are doing. And I was just curious, as ideas come up and we think about compliance with federal law, are the ideas being floated in light of those, or is the idea to put all the ideas on paper, come up with recommendations and then decide if we're still complying with federal law? I just want to make sure we're not, we have an idea of how we're going to address the federal law issue.
So I can take that on, then Angie knows more, but I'm also very interested in that, Representative Mueller. So to be clear, the federal requirements are not federal, they're not federally required that our laws reflect and be the same as what the federal laws are suggesting. Those federal requirements are tied to funding. And maybe you actually know more about that than I do, but when we're looking at our state and looking at what's good policy for Minnesota, we can look to the federal requirements and see well, what are they suggesting that be done, in this situation? But we're not going to be out of compliance and have an illegal predatory offender registry scenario. It would be something that if we don't have a piece that the feds or the federal, framework suggests, then there's a monetary impact. We wouldn't get a certain amount of funding. And Angie's really knows more about that than I do. But I think that's another thing that we need to be really clear on, is that we don't have to follow some federal mandate. It's a funding issue. And so we get to decide in Minnesota what's good for Minnesota, and certainly look to the federal requirements and see, or the federal, I'll say, suggestions or framework. But we get to decide what's good for Minnesota.
Representative
Yeah,
O'Neill. Oops.
I was just, go ahead.
Go ahead.
I was just gonna say, yeah, my understanding is that it's a set of minimum standards, and the idea with them is to try to close any gaps and loopholes nationally. And there's a amount of funding associated with each state based on population. And so there's a big, I can get the numbers. I have them and I don't know what I did with them. But they have it even online. It indicates if you go to the SORNA website, you can get all kinds of information on that. And it'll say by state, the amount of money that they could get potentially, how much compliance they are in with the standards. And there's I think it's a 10%, if you're substantially in compliance, a 10% penalty. And it's kind of an annual thing. And then you can you can get the penalty back, and I think then you have to use that money to try to come into compliance. I mean, the idea of these is to have people in compliance with them, even though they're not mandatory. And I don't know that Minnesota will ever be, because we have a separate risk level system, and theirs has it incorporated kind of into the federal standards. But I can try to get, for one of our future meetings, I'll try to get better information together for exactly what's going on. And Kelly, to answer your question, or Representative Moeller to answer your question, the other chairs can correct me if I'm wrong on this, but I think we talked about kind of providing all of the information to the legislature in the report, pros and cons of the different ideas, potentially with some language, if we come up with some language that we think would be helpful. And then also as part of that report to say, this is what the federal law requires or suggests, or what the standards are. And this is how Minnesota would be affected if we're not, or is affected if we're not in compliance, and maybe even be able to give the numbers for the last 5 years as far as how that affects funding or could affect funding, if that makes sense.
Representative O'Neill.
Thank you. Yeah, no, we would need those numbers. And then also, where does the money go? So like what agency, or like for what fund does it go to, or what is it used for? I think, so if we're not going to do these federal minimums in a certain area, we would need to backfill most likely. So we'd have to have that as a decision point at the legislature, which I think is what Representative Mueller was kind of getting at. But if you could give us some specificity as to the 5 years, would be helpful, but also specifically what is the money for, and what agency is the agent that handles the money. Thanks.
It's my understanding it's a DPS thing, or a BCA, that they're the ones, and Katie's on in this group if she wants to comment, but they're the ones that work with the federal government, and that funding, the grant, and when it's denied, and getting the money back, and all of that.
Yep, so the BCA does receive some funding. I'm not sure who else receives funding, if I'm honest with you. I would have to look it up. There is the SORNA website, which shows substantial compliance in our last review, which was in 2015, I believe. And I'm happy to send that review and that report out as well. And I'm happy to figure out how much funding, at least for us, is attached to it. So I can definitely ask and get that information.
Thanks. And just a quick follow-up. So I think it's also important to distinguish whether or not that is for solving crimes, or is it for victims, or there's all kinds of places that could go back out, but it's really important for us to know what is the allowed expense for those funds, if there is any.
Yeah, I'm happy to look that up. I'm not sure what, I don't have any of the information on me, so I am happy to figure out the status of that, what it's attached to, how much it is attached to, and the potential risks financially for lack of compliance.
It would all go into a fiscal note. So if we move forward with any part of that, you'll get that question officially so that it will appear in a fiscal note. We'll know how to backfill. Thanks. Thanks for
Look
the
at you guys
conversation.
prepping me for the fiscal note process, getting me all ready.
Well, I was gonna
Yeah.
say that's something that's come up on this issue too, in a couple of different subgroups and maybe even in the main group. The SORNA does not have a same set of circumstances requirement. So on that particular issue, which has come up a lot, that wouldn't affect that. And also on the juvenile registration, they require registration for the most serious juvenile offenses, not for all juveniles. So just so you know, those are kind of two things that have come up a lot, and that's how the federal regulations have dealt with them.
So just a little bit of background on this, the SORNA requirements. These were passed about 15 years ago, and since that time, 17 states have come into compliance. Minnesota is not one of them. In 2020, those that are out of compliance in Minnesota, those grants are called burn grants, and they were about $2 million state sources for Minnesota. So the penalty would be about $200,000. It doesn't affect local units of government who get those burn grants. It's only at the state level. And then that penalty money, as Angie said, is available to work on those items that bring the state into compliance. And much of that money, I believe, over the years has gone to BCA to upgrade their systems. But they can provide
Actually, we
more
were
detail.
funded by the legislature for our most recent system.
Yeah, just over the years is what I'm saying, is those extra burn grants. Patty.
I just wanted to, I'm sorry I was a little late, but so maybe this isn't relevant, but Minnesota had the levels that SORNA is required before SORNA existed. So we have to, I like Stacy's mindset of having to go, we were ahead of the game, and then they set up this criteria. So we have to be mindful of not going backwards and doing what's right here. And we also have to attach to it the cost of getting in compliance might not be worth the money that we're losing. So, you know, all those dollars have to come into play. And I think that in many ways we were leading the game, and I just want to make sure that we stay in what's working the best. So I really appreciated all of the committees that I sat in and the really depth of the discussion. But I don't want us to be afraid of moving forward with what's best for fear of losing federal dollars, because the cost of getting into compliance is what keeps most states from going there. Sorry.
Okay, Brian.
Support what Patty was saying and some of the others about our system is based on risk, and we look at the whole individual and a variety of different factors based not just on their conviction, but their whole history and them as a person and individual. Take a lot of factors into consideration from a risk standpoint. My understanding of the federal statutory requirements and the tier levels are really based on conviction only, which is one of the downfalls in my estimation. So I agree with Patty in that regard. I think we're doing what's best practices at this point already in assigning levels.
Okay, any other questions, comments that anybody has? Seeing none, I will hand it over to Stacy, who has some presentation today. Or is that?
Yeah, I'm not presenting, we have 3 people here today that are prepared to talk about the unique perspective and subject matter expertise that they hold. And so we can just start with those. We're shooting, just so people here know kind of time frame. It's now 9:42. We're shooting for about 10 to 15 minutes for these speakers to present. We want people to be able to ask questions because each brings a really unique perspective. So I'm super excited to have them here today. And we didn't really talk about an order, I don't think. Mark, can you tell me if there was an order that you contemplated for how we should proceed?
No, you can go in whichever order you.
Well, let me
want.
ask if the presenters here have a need to be at something else a little bit, before the meeting ends. I would want to give priority to whoever needs to cut out. Luis, Keila Marie, and Sean, do either of you have a need to be done with this meeting before it's over by 11?
And Luis, if you could unmute in order. Okay, good. And Sean. There. Okay.
So if anyone has a need, then we could go in that order. If not, I would propose that we have Luis present first.
I have no issues with that.
Okay, thanks, Sean. So Luis, if you're prepared to go, I'll let you introduce yourself because I can't do justice to who you are. I think you can do a way better job introducing yourself and your background and what you do.
Good morning, everybody, and thanks for having me today. My name is Luis Rangel. I'm an attorney, staff attorney at the Neighborhood Justice Center. It's a nonprofit organization in St. Paul that helps the East Metro community with criminal defense representation. We try to target individuals we try to service individuals who perhaps make a little bit too much to qualify for a public defender, but do not make enough to retain a private counsel. So we try to fill that need. And so I just wanted to talk to you about some of the issues that I see come up with predatory offender registration, both in practice as a defense attorney, but more importantly from a rights perspective and liberty issues that I see arise and that are problematic. And I'm more than happy to answer any questions about any statements that I say that may be perhaps contentious or people may disagree with. I'm more than happy to try to hash it out. No, it's not a problem. So as an attorney at the Neighborhood Justice Center, I've been there since, serving as an attorney since 2015. I've been there since undergrad, working as a volunteer and then going to law school and so on and so forth. I've had the opportunity to work on a variety of predatory offender registration cases. I've had an opportunity to work with prosecutors in cases that would involve predatory registration or in which predatory registration is leveraged as a way of resolution. And what I mean by that, and so the first issue that I wanted to talk about is sort of something that I think Officer Heck and Ms. Keys noted about is sort of the need for data about how this law is actually working. And the importance of that is because anecdotally, I can give you stories in which it seems that it's not working, but it would be unfair for me to say that it isn't, because I'm just one attorney working with one particular prosecutor in one particular case. It's unfair for me to be able to extrapolate that one particular instance and apply it statewide and whether or not the law is having its intended effect. But what I will say in terms of that is it's not uncommon for a defense attorney to have a discussion with a prosecutor in which predatory offense is considered as a leverage to resolving a case. And what I mean by that is that you could have, for example, an individual that's charged with a domestic case. You can have an individual that's charged with something less severe than actually, in terms of sentencing, it might actually be considered more severe, but predatory offender registration carries, although it's considered a collateral consequence, it probably carries the harshest consequence from a particular case. And so it's not uncommon for me to run into a situation in which a particular prosecutor says to me, you know, if your client doesn't resolve your case, we will amend the complaint and add things like false imprisonment or something that could trigger, and it's usually false imprisonment, that will trigger predatory offender registration. And so think about that for a second in terms of what that means for someone who all they're doing is exercising the right to a trial or exercising the right to their procedural process that is guaranteed by the Constitution. And that is that you have someone in their discretion that is saying, for whatever reason, whether it's, they're saying if they decide to execute that right, we will charge them more severely. And then if the outcome is not like your client hopes, they will have to register for the next 10 years. You know, I find that incredibly problematic. I think that type of discretion is a problem, especially when you consider that almost every domestic case could be potentially a false imprisonment case. If someone is being held or if they say I tried to leave and someone prevented me from leaving, you arguably have some fact patterns that you could survive probable cause and have a trial on a false imprisonment case. So that's issue number one. The other issue that I wanted to talk about briefly was sort of the complicated nature of the form and who is being asked to follow this law. So one of the things that immediately came apparent to me while I was a student, even just as a volunteer or a certified student attorney with Neighborhood Justice while I was in law school, is that this particular document is like 11 font, 4 or 5 pages back and front of 60 some, 70 some paragraphs that individuals are expected to follow, which is incredible. I mean, I think everybody in this particular room would have problems understanding that document and also following the document. Everything from, it's just in a bureaucratic sense, it has to be more, whatever comes out of this, it just has to be more practical. It has to be easier to understand. Individuals should have the opportunity to understand what is illegal and what is being prevented from them. When you mix it all up into a situation in which everything becomes important, then it's really hard for a person to understand what the requirements are. And then you take into consideration the particular populations that are being asked to register. It makes it even more problematic because a lot of times you're dealing with individuals that haven't graduated high school or have a GED. A lot of times they obtain that GED while they're incarcerated. So it's really confusing in general to follow the law. I'll give you an example. So one of the things that is required is within 5 days of moving from a location or within a certain amount of time, you have to notify or provide notification that you've moved. And that makes a lot of sense if you have stable housing. If your housing, if you've lived in your house for the last 10, 15 years, and you're not going to move for another 10, 15 years, that makes a lot of sense. You have to report that within 5 days. By the time you get to your closing of your home or your second home or where you're going to move, you've had plenty of opportunity to be able to notify the state that you're going to be moving. But the reality is that the populations that we deal with, and it's been evidently true during Zoom, during the pandemic when we're doing Zoom court, is a lot of individuals who end up in the criminal justice system struggle to maintain a current phone, and are bouncing around between apartments or between family members or couches, and so you're asking the most vulnerable population that struggle with homelessness and who struggle with finding housing that's stable, with the most strictest requirements in terms of notifying where it is that they're living. Now, it certainly makes sense. It certainly makes sense if what we're saying is that this is helping solve an enormous amount of crimes and that individuals who are on this predatory offender registration are committing these offenses. But the reality is what we learned during the working group for the criminal sexual conduct working group and Ms. Bettinson trying to get data information on this is we don't really know. We were told that it does, but we don't really understand to what degree it's actually helping law enforcement. But we do know the implications that it's having on these vulnerable populations. And again, a lot of times it's not individuals. I'm not talking about individuals who are convicted of serious criminal sexual conduct offenses, which, you know, we in the last working group, I think we differentiated between that group. I'm talking about the populations who are either were underage when they were required to register, or individuals who end up kind of getting caught in this really expansive net through a criminal justice process that is just inherently unfair. So, and those are that's the population that I think when we talk about reforming, that's the population that we're talking about. How do we provide those individuals a right to be able to get off predatory offender registration, or whether those individuals should even be required to register? Even more troubling is that back in like 2017 or 2018, or sometime not in the too distant past, it was amended to require homeless people to check in with law enforcement once a week. And that if you don't check in with law enforcement, it becomes a violation of the predatory offender law. A law that requires a mandatory prison commit for a violation and a mandatory 24 months for a second violation. When we view it as, I think the view behind it is that this is intentional and malicious, that violations are intentional and malicious, when in reality, they appear to be just more of a lack of resource and a lack of ability of individuals to be able to comply with a law that is so complicated. And reality appears to not even be data driven. So those are my comments. I know I try to break it up into 2 or 3 particular issues. So if anybody has any questions, I'm happy to answer them. Otherwise, I'll defer to the other individuals who are here, especially Keela Marie, who I have the utmost respect for. So. Yeah, I don't know if I can call on people, but I'll call on Ms. O'Neill.
Representative O'Neill. Yeah.
Representative O'Neill.
That's fine either way. Thank you. So in what you just told us, I'm particularly concerned, I'll use that word, about prosecutors using the power of their office to threaten to add a charge that would then land them on the predatory offender list if they don't plea. And that's incredibly abusive of power if that in fact is happening. I believe you said you were in East St. Paul, and I'm just wondering how many instances have you personally witnessed of that abuse of power?
Well, I wouldn't. So here's the thing about that, Representative O'Neill. I wouldn't consider. I don't think it's deemed abuse, because I think the alternative is that a prosecutor charges it out because the registration attaches the moment that it's charged to a complaint. If a prosecutor was to charge it out immediately, it becomes a complaint that is unresolvable. Or if it becomes resolvable, it becomes incredibly difficult to resolve because of the offender registration. So I think it's more about discretion and how a particular prosecutor, and I'm not trying to say that prosecutors are being malicious about it. I think that what ends up blatantly occurring, though, is you create this system that becomes unfair. And what I mean by that is, if that particular prosecutor who has that particular mentality of approaching it in that way was to charge it out to begin with as a false imprisonment domestic abuse case, that person is going to have to register regardless of whether or not they get acquitted of the false imprisonment case. It could be charged to a misdemeanor domestic offense. And then that person will have to register for 10 years. So in reality, there's 2 ways of looking at it. In one way, a prosecutor is withholding that type of charge. And then in the other way is being leveraged to resolve the case, which I don't have the answer for it. I just know that when it becomes used as a bargaining chip is when it begins to seem unfair as a whole and in a process that then dissuades individual from exercising their rights to a trial. My job is just to assure that people are afforded their constitutional guarantees. In other words, that they have their right to trial and to assure that their rights were not violated by the state. I think a lot of times defense attorneys are looked at as, we're helping the bad people. But in reality, I really consider us as like the first line of defense that preserves constitutional rights. And one of those fundamental constitutional rights is the right to a trial, the right to be heard, and the right to have your day in court. And for better or worse, it doesn't happen very often because the consequences, even though they're not considered consequences in law, collateral consequences are not deemed part of the, per se, the criminal justice system. That they're considered, as the name entails, collateral consequences. Predatory offender registration is an incredible consequence. I mean, that's what it is. To have to register and be labeled as a predatory offender is life-changing, I would imagine.
Really
Sheriff
quickly
Heck.
as a response. Sorry, really quickly. So I just want to be clear. These are behaviors that they did most likely commit. Obviously, we're talking about charges, so they most likely committed false imprisonment, which now the prosecutor is withholding that charge, saying, well, if you plead to something else, I won't charge you with false imprisonment, which would put you on the POR. So I'm just wondering if you could just tell us like how many times you see that, because that is really a relevant conversation that we've been having here in this, the large group and in the subgroups, as far as how often are you seeing that? Because obviously the POR is supposed to capture predatory offenders that are preying on other people and a risk to society. And you may or may not be describing that. I'm not sure, but if you could just kind of qualify how many cases you may, is it a dozen? Is it 2? Is it 30? Is it 100? Like, how many cases have you seen?
Yeah, I mean, it's hard to put a number on it, and it really is dependent on the particular office and prosecutor that you're speaking with. You can run into individuals that have a particular reputation for being that type of, that's their way of resolving cases, is by leveraging things or trying to charge more severely in different cases. I mean, for better or worse, it's a particular style of prosecution. What I will say is, I think in general, people understand how easy it is to get onto this law, because what I'm saying is that just about any minor offense in which an individual says they did not feel that they could leave becomes a predatory offender case. So the net is so broad on this law that just about, domestic related cases are essentially a huge chunk of the criminal justice system. And if I'm to answer your question, if that's the intent of the law, then it's failing, because everybody, so many people would probably qualify to be under predatory offender registration. And that seems not correct. Like that, I don't think that that's the purpose of predatory offender registration.
Thank you.
Sheriff Heck.
I appreciate Luis's comments regarding the appropriateness of prosecutors carrying this out, because I just wanted to point out what's already been mentioned, that these are people who there is probable cause to believe they've committed the crime of false imprisonment. This isn't someone that, this isn't a crime that a prosecutor is plucking out of the sky at random and threatening somebody without any cause. So as already been mentioned, these are crimes that already could have been charged that have been withheld. And I would just urge caution at characterizing this as a systemic problem when so many of these cases are very specific fact driven, and that without being able to sit down and look at the independent facts of each case, it's difficult it would be difficult for me to say, hey, you know, I think this is a systemic problem because it's happened in this case, and, you know, as far as the right to a trial, I appreciate that registration on the POR is a big deal. I'm not trying to downplay that. I would say also that anytime a defendant goes forward with trial rather than taking a plea arrangement, there are risks that defendant is taking upon themselves. There's the risk that they're going to be found guilty. There's the risk that they could be facing a stiffer sentence. It isn't like registration on the POR is the only thing that a defendant would have to consider when deciding whether or not they wish to proceed to trial.
So just in reply to that, I'm sorry, I don't know your ranking, but so I'll just refer to you, Mr. Heck. I agree with everything you said. And the only thing I think I would highlight is, I think the unfairness comes in the fact that the question for this work group is whether that type of consequence should be sort of willy-nilly, because that's ultimately how it ends up feeling, and it becomes a matter of luck on whether or not you have a particular individual that wants to leverage it in the way that I just described. And so, yes, I agree with everything that he said, and I'm not trying to, I have the utmost respect for our prosecutors and the role that they play in administering justice and assuring public safety. I mean, it's a adversarial system, but it requires every party to do their job diligently for it to work. And without that, you know, it sort of falls apart. So it requires all pegs to work appropriately. And I think it's for this group it's being tasked with the question of sort of defining how much discretion or how much discretion or how much power to give to any one particular individual that they could do that.
Angie.
I was just gonna say that and Katie can correct me if I'm wrong, but the vast majority of them that we see do not have those amended complaints. They're just charged in the first place with the false imprisonment and convicted out of the same set of circumstances. But that being said, maybe it was never charged out because it was resolved based on that pressure. So, but I just wanted to say that we don't see a lot where it's an amended complaint to the false imprisonment or to the registration offense. We mostly see where they're charged in the first place.
Renee.
Yes, Louise, I just want to say that I appreciate you bringing to our attention how complicated that form is, the registration form, and how long that is. In my years as a probation parole officer, I had a number of individuals who were lower functioning or had some kind of learning disability, where even after their time on supervision, they were still stepping into the probation office to make sure that they were in compliance, getting numbers switched around, then getting those notices that they're not in compliance, and how that created such anxiety for them. So thank you for bringing that to our attention. In the methods group, anyway, we have not discussed that. So thank you.
I would encourage everybody to, or perhaps if Mr. Bliven can circulate the actual form. I don't think I can describe it well enough because it really seems like it's a mortgage contract of some kind that requires initials at 64 different locations. And it's difficult. I mean, when you think of the requirements, it really is difficult. And from a fundamental fairness perspective and procedural fairness perspective, the purpose of a law is that an individual is supposed to understand what's illegal. I don't think anybody here is in the business of trying to trick anybody into committing a crime. But when you take the particular populations that end up getting put in here, as Ms. Meerkens noted, is what we're seeing, it's a very particular group. I mean, I'm not even going to start getting into the fact that once you break down even that group even further, you start dealing into the racial discrepancies. I mean, that's the reality of it. So it's targeting a particular population unintentionally, it seems. And we don't really know the numbers to really be able to support the continued sort of obligations that it's having on people's liberties.
So I'll have Katie and Olivia provide that form since that's a BCA form. So Stacy.
Yeah, really briefly. So, excuse me. So Luis and I and Keela Marie too, and Sheriff Heck were on the CSC working group. And what our report to the legislature, which Representative Mueller is well aware of, in supplement 2 to that report that came out of the CSC working group, was a proposed revision to the statute that would address this issue of, let's just call it the false imprisonment, domestic assault scenario. But there's many other scenarios which this case would come up. But we provided a proposed amendment to the statute under 243.166 subdivision 1B. Registration is required when, and with the help of Shane Baker, who's the Candy Ojai County Attorney, we revised the statute to require registration when the person was convicted of a felony or attempted to violate, aid, abet, conspiracy, commit any of the following. And it has all the offenses listed. By taking out charged with or petitioned with, and making it just a conviction of these crimes, that would take care of that. And then we also removed the or convicted or adjudicated delinquent for another offense arising out of the same set of circumstances. That topic, that whether this amendment to the registration required section is the topic of the crimes subgroup. That's one of the big issues that the crimes subgroup will be looking at, and whether we remove the language from the statute that requires registration if you're merely charged with an offense that requires registration, and arising out of the same set of circumstances. So there's a potential solution that we came up with in the CSC working group after working really hard on that particular section of the statute. And we had the prosecutor, Shane Baker, is the one who revised the statute, because he had some thoughts on why he as a prosecutor didn't like that language, and why it was difficult for him as a prosecutor to work with this language. So we have that, and my hope is that the crimes subgroup can take a close look at that proposed legislative amendment, and maybe that we can move that forward. And Luis, I think you're familiar with that proposed.
Yeah, if I could just, I know it makes a lot of sense to me, but for the non-attorneys, what the current law entails is, say for example, Ms. Bettinson was charged with a domestic. They added a false imprisonment, and then they either tab charged or added at the initial start disorderly conduct. So at that point, under the current law, she would, if she loses on any case or is convicted of any case, whether it's the domestic, the false imprisonment, which is the charge that would trigger the predatory offender registration, or the misdemeanor disorderly conduct, she would be required to register. So she could go to trial, or she could resolve the case. And if she was to plead to a disorderly conduct, which all that requires to plead to a disorderly conduct is to admit that you were noisy or boisterous and caused alarm in others. That's what a disorderly conduct is. And she was convicted of disorderly conduct, even though she may have been acquitted or the charges for false imprisonment and domestic were dismissed, she would still be required to register. Simply because the false imprisonment charge was added or was part of the complaint. That was one of the, I think, you know, for as much contention as there was in the criminal sexual conduct working group, the most consensus that we found amongst everybody, including the prosecutors, and I don't see anybody, I don't know if they're here today, but anybody here representing them today, but was sort of this issue. Like, I think we all understood that it is not working. And you know, just I'll leave with this comment too, in terms of, it's not just when an offense is committed, right? So like, if a person was to commit a subsequent offense after, say a person gets convicted of a disorderly conduct and they got acquitted of these other 2 charges, and they were on year 9 of their predatory offender registration. If they were to commit a subsequent offense, whether it's a DUI offense, a disorderly conduct, a misdemeanor theft, a public nuisance, all these minor things that we see all the time, not stopping at a crosswalk for people, which is also a misdemeanor offense, and they are convicted of it and are given any form of jail consequence for it, the tenure starts all over again. So you have the capacity to have someone be on this law for that, and I've seen it. So it's those, whether it's 1% of the people that get trapped in this law, it is 1% too many. Like, it should have its intended effect. We should understand how it's being used by statistics and have a driven based law. So whatever it is that this working group decides is the purpose of this law, it should be able to be supported subsequently by the statistics of how it's being implemented.
Representative O'Neill there. COF.
Yep, thank you. So just in relation to that, we had kind of a legislative history of the POR, and I'm trying to remember, I don't know if it was in Katie's law, part of it where we added back in, I wasn't physically at the legislature at that time, where it was some of these names and similars were added back in, specifically the false imprisonment, which now is captured, as we've talked many times now about domestic assaults. I'm just wondering, I mean, it was the BCA that did the walkthrough. Was the intent of, okay, awesome, thank you, Olivia. Was the intent of so as you look through the legislative history, was it the intent of the legislature to capture those that had domestic violence charges, or were they more so sexual offenses?
Let me pull up the presentation really quickly. And is it okay if I circle back in just a couple minutes once I've pulled it back up?
Absolutely. I just think that this is really key to the full conversation, because this has come up in every single subgroup and now in the working group of who did the legislature intend to capture versus who are we actually capturing? And that's been a contention, I think, since, I mean, as long as I've been at the legislature, that's been a concern. So, that would be helpful to get that distinction.
I think that's incredibly informative as well. And what I will add is, you know, I think the question is whether, or whatever the legislator intent was at that time, the question is whether, I think it's whether that should be the case going forward. And that's not for me to answer. This working group will have its discussions around it. But there, for the non-legal minded people who aren't unfamiliar with the laws of how domestics work, but when an individual commits a first time misdemeanor offense, they push someone, they slap someone, they hit someone, and that person is a domestic partner or a family member, that is deemed to be, and the person has no criminal history, that is deemed to be a misdemeanor offense. Okay. The second time that occurs, it's within a 10-year period, it's deemed to be a gross misdemeanor offense. And the third time it occurs within a 10-year period is considered a felony. So if it was intended to capture, if false imprisonment was intended to capture the domestic cases, you have a situation in which the punishment in other areas of the law is not, the gravity of it is not matching up with this particular collateral consequence, if that makes sense. Because a misdemeanor offense, you can be on probation for up to a year and a 90-day consequence. But if the intent is also to include false imprisonment, and don't get me wrong, there will be times where a particular fact pattern is put before a prosecutor that merits a false imprisonment charge, and that a particular offender is so, offices will be accustomed with particular individuals that they say enough is enough, and they add the false imprisonment charge because they feel it's warranted. I'm not taking away from them. Absolutely, those circumstances exist. There are people that are victims of domestic violence that need to be protected because, for better or worse, they're in a in a relationship that perhaps doesn't seem to, they're not in the capacity to be able to end it themselves, that relationship, right? So I'm not taking away from that. I'm saying just in general, the overall situation of how domestics work and how, whether that's the purpose of a false imprisonment charge, is to sort of cast it so broadly, and the language is so vague, not vague, but so broad that it allows that type of leveraging.
So I was able to pull up the presentation. The change for adult specific false imprisonment was made in 2005. It was in response to a number of hearings that were right after the Drew Shadeen case, which involved a number of elements. And so I believe that was a direct response to the discussions around that. I can pull up some of the historical presentations if that would be useful for folks. So let me know what you would prefer.
So Stacy, but just a caution on our time here, since we want to make sure that the other two presenters have time also. Stacy.
Yeah, that's all I was going to say. We should have, this topic that we're talking about can be hours and hours of discussion for sure. And it's because it's so complex, but I just want to be mindful that we have two other speakers. We have Keila Marie, and then we have Sean, who is going to speak as well. So I just wanted to see if we could, if there's other questions, I don't want to stifle that, but I also want to be mindful of time.
Okay, Representative O'Neill.
Thank you. I just was encouraging when Olivia comes back with all of that information, I think it's really important to understand that a lot of times the legislature does a reaction. And if it was based on the Drew Shadeen case, which was egregious, and now we've captured in domestic violence cases that are not Drew Shadeen's case, yeah. Anyway, I'm just gonna leave it at that and we'll listen to the next presenters. It's what the legislature does best. You take the worst case scenario and it casts aspersions on cases that were not that.
And I guess I have a quick question. Did folks want me to pull the historical data for that? Or I'm seeing a lot of nods. So I'm seeing yeses. Okay, will do.
Stacy, did you want to introduce the next speaker? Or
sure. I'd like to introduce Keila Marie Granda, and I will let her do her own introduction as well.
Okay, can you hear me?
Yes.
Okay, great. Thank you. Hi, my name is Keila Marie Granda. I'm the Executive Director of Unspoken Voices, a nonprofit that really works to elevate the voices of those previously or due to oppression, marginalization, systems issues, et cetera, to raise the voices of those really not being heard or advocated for. I'm going to keep it extremely extremely short and extremely sweet. Basically, I had the pleasure of walking alongside a lot of great folks as part of the Criminal Sexual Conduct Reform Working Group Steering Committee. So for me, it's a good time actually to come back into some of these meetings and see familiar faces and to be able to think about those connections and really just wanting to, as the voice, that was really representing victim survivors and advocates, and at times those from the BIPOC, queer, LGBTQ communities. It's really important for me just to carry forward some of the things, the visionary outcomes we had within the CSC group when it comes to POR reform. So I just wanted to make sure that everyone knows that this was something that was advocated for across the board, and that there was a consensus that things need to change. If we really want to serve victim survivors, then we need to make sure we are doing everything we can to really serve and support victim survivors. Sometimes it seems like it's a hard dichotomy for people to understand that victims can be offenders and offenders can be victims. So that's a huge part of I think, what my messaging is to remember, especially when it comes to our juveniles, that there are other ways, there are better ways, and there are other states that have done the work. And I think in addition to advocating for our juvenile youth, I also want to just point out that at this point, the registry has become so large and cumbersome that it is, in my mind, such a large beast that at times we're not able to actually get to the worst of the worst. If we're actually looking at predatory offenders, we need to be looking at predatory offenders. And so I think we really need to do our due diligence and make sure that we're serving our victims, supporting our survivors, and that's making sure that we have a registry that is doing its job as it should be. So just carrying that forward, hoping that this amazing group of people will be able to come to a consensus on some of this work. I just want to say thank you for everything you're doing, carrying it forward. And I hope to be of some support or collaboration or be here to answer questions in the future or at a later date. So otherwise, feel free to check in with Stacy or Mark for my email as well. So yeah, thank you.
Any questions, comments? Stacy, did you want to go to our next speaker?
Sure. We will bring forth Sean. Sean, you can unmute and and put on your video if you're able. Hi, Sean. I'm gonna let you do your own introduction as well. So you have the floor.
Thank you. I just want to say before I go forth with this that my intent today is just to share what I've gone through, to talk about how this has affected me, about the struggles that it's put in my life in an attempt to do the correct thing and to move forward and be a positive member of society. So I don't want anything that I say to get taken as a put down or a justification for anything that I've done. I take full accountability for my actions in the past, and I'm very open about them because those are parts of my life. So whatever I say today is just to put forth where I'm at, what I've dealt with, and to give a clear understanding of that. So with that, my name is Sean. I am 37 years old and I have been on the registry since I was 15. That is 22 years of my 37 I have been on the registry. It started when I was 15. I committed a crime against a family member. I had a lot going on in my life. I had dealt with a lot of traumas. I was very misguided, very angry person. I didn't understand the world or the magnitude, and I honestly didn't have a lot of care in my life at that time for anything. I was charged with a second, pled down to a fifth, and ended up doing 4 years in juvenile detention because I couldn't complete the programs. I did those 4 years. I was finally able to complete a program prior to my 18th birthday and was released. I was sent to a foster home where I did outpatient treatment and completed high school. My foster family put me on SSI and sent me to an adult foster home on my 19th birthday. And I spent the next few years learning how to take care of myself and how to be responsible for my day-to-day life because I had not had that. I had never had any training in that. So needless to say, during that time, I struggled with mental health. I struggled with addiction. I struggled with interpersonal relationships, emotions management, all sorts of things. I had a few, not attempts, but bouts that I had contemplated suicide. I spent my life living in fear with the label. I was not honest or open with anybody because I assumed that I would be rejected. That later, all those behaviors later led into a second offense where I had a statutory third-degree case and a failure to register. When I was released from juvenile custody, I was not explained the magnitude of the registration process or my requirements. And I saw it as not a big deal and I didn't follow through on it. So I ended up going through the legal process and through my adult, at this time I'm 22 and I'm going through the legal process, and I haven't dealt with any of the issues that really affected me at that time. And I continued to just think and feel and act the same, not in terms of hurting people, but just not caring, not showing concern for the rules that were laid forth for me. Led into some parole violations, and I was essentially jailed. My adult charge consisted of the failure to register and the third degree. I was given a concurrent sentence on both, and then I was given 10 years of conditional release on top. So I ended up spending 8 years of my 10 years of conditional release in Minnesota Department of Corrections. I eventually completed treatment, CD treatment as well, and was released. Prior to my release, I had to pick housing. And in my area, housing is very limited due to an ordinance. My case manager at the time with the Department of Corrections warned me that going there may be a sentence to be sent back for not having housing, and that I should go somewhere else. But I didn't have anywhere else. And so I chose to come back here, went to a workhouse. In that workhouse, I was there for about 45 days out of the 60 that I was allotted. I was removed because other residents there were physically assaulting me and threatening me, and I was choosing not to respond to that. So they moved me for my safety. I was put into a adult parole facility, like an outside house to help find housing. Upon being there, I was told I had a time limit due to the ordinance, which only allots for about, I would say, 15 to 20 blocks, an entire city of over 100,000. I was not able to find housing. Housing for an offender is also not only just finding housing, but I cannot rent to a rental agency. So anybody who has a property management won't take me due to a criminal history. I have to find somebody who owns their own property. And then on top of that, you have the public notification and stigma. So it's very, very difficult, as is without an ordinance, to find housing. Because of that, I ran short, and within a few days of being sent back for not having housing, I was able to find a place in another city, an hour away from my support people, away from my treatment group that I was going to and thriving in. And I ended up living in filth and cockroaches because it was the only place I could find to live. Upon moving there, they did my public notification. Within 2 days, I had a neighbor throw a videotape through my window and scream at me. I was walking to work at the time and had people drive by and scream things at me and then make a circle back, and I ended up having to run away from them. I had reports that I made at the time in that place where police didn't take them seriously or told me that they weren't going to help me. It got bad enough that my mental health was suffering. I missed my group. They were supportive for me, and I moved. I'm so blessed. I just on a random chance was able to find the apartment I currently have, and I moved back to the town that I was originally doing parole in. Once I got there, it was fairly quiet for a while. I finished my treatment. I finished my parole and was released from that obligation. And I started to have some other issues. I was being contacted on social media and threatened. I had had several relationships where I had been honest with people, and they looked up my level notifications and chose not to continue to talk to me. I had social interactions where I was doing positive things, playing sports, whatnot, and somebody, whether they didn't like me or just thought they knew me, and they would look me up and toss that information around, and I would have to leave those circles and give up those activities, to the point that some of my activities have been very limited because of that. I went on from there, though, continued to use my support, finish treatment, go to support groups, do everything that I'm supposed to do. And I went through child services to contact my daughter. I was approved through a county hearing to keep my parental rights, because if you're a registrant on the registry, your parental rights are terminated if the court does not warrant that you are no longer a danger. So just being on the registry considers you a danger, and your parental rights are taken to court to be terminated. So I had to fight that, and I was able to keep them. I had done enough in my life that they saw that I was making changes. And this last year, I applied for a level 3 reduction and was granted that due to my progress. And I'm grateful for that. But I am a lifetime registrant, and I will have to register for the remainder of my life. Some of the stuff that goes with that is a daily worry that I'm in compliance. We don't really have any way to check and see if we're in compliance. We can call the BCA and ask, but beyond telling us you are in compliance, there's nothing. Like if I call and say, is my paperwork been sent this month? Because I haven't received it, and I usually receive it at this time, they can't tell me. If I call and say, did you receive my paperwork? They sometimes will tell, but I don't think they're supposed to. There's so many rules that come out every year for this that I have to reread the paperwork multiple times to make sure that I didn't miss anything. When I send my paperwork in, I take photos of the envelope with a date on it so that I can prove that I sent it in, because we all know that the mail screws up sometimes, and I don't want to be responsible for not being in compliance. The public notification stuff, my face will forever be on the internet, just because of the public notifications. The public notifications for the level 3 created issues with my housing, work, recreational. There's things because of the registry that I can't do that are positive. I used to play basketball at the Y with professionals every day at lunch, and it was something I loved. I can no longer use most gyms because I'm on the registry. Most gyms have a policy that state registrants can't be there for their insurance safeties. The harassment, again, public, everything. I've lost relationships over it because they can't take the stigma from their families or friends about why they would hang out with me. I just think that at the end of the day, if I'm making choices to make an offense or to create an offense in a victim, then I deserve those consequences, and I deserve what came to me. But I am not what my past is. I get to make a choice every day to do something different, to be a different person, to think differently, to act differently. And I do that despite all the mental health stuff I've struggled with, despite the rejections, despite the depression, anxiety. I don't want that. I don't want to create another victim. I don't want to put my family or my friends in those positions, and I don't want to put myself in that position. So I choose daily. And I just feel like, what motivation do I have as a registrant who knows that I will be dealing with this fear and anxiety my whole life, this rejection because of a choice I made, even though that's not me now? What motivation do I have to go forward? Not everybody that comes through this situation is as strong as me or as willed as me. And a lot of them give up. A lot commit suicide. A lot decide that they just can't live under the stress and create another crime and go back. A lot of them are addictive people with personalities, and they have substance abuse, and they can't handle the stress, and they go back to the substance abuse, which causes more crimes. This isn't everybody. Some people make the choice to do those things, but there just is so much stress associated with being on the registry and so much restriction that it's at times unbearable. And one last thing before I open up is I want to put this out there. Yesterday, I'm low income, and I was trying to get some help with housing because I live off of an extra probably $100 every month beyond my bills. And I was turned down for housing because I'm a lifetime registrant. So I cannot get public housing because of federal guidelines. So in all senses, I'm basically restricted. I am not able to move because I can't afford more. It's just a horrible situation. So there are many things that aren't seen. So I'm going to shut up and thank you for the time. And I'm open to any questions if anybody has them.
Representative Moeller.
Thanks. I want to say thanks to all the presenters, and Sean, thank you so much for sharing your story with us, and congratulations on all your accomplishments. And I do really appreciate you sharing your story in this public setting, knowing all the things, negative things that have happened to you over the years. So thank you so much. One thing that I've learned about today that I didn't know about was just the paperwork requirement and how onerous it is. We heard Luis talk about that. You've mentioned that as well. And, I think most people realize that once your criminal case is over, you don't have an attorney anymore. And so the idea that the rules are changing and you have new paperwork and new requirement year to year, is there anybody that you had to help you sort of sift through what those changes are, or were you on your own to figure those out?
The news if I request the paperwork, but if I don't keep up with the legislative, if I don't keep up with the lawmaking, which I will be honest, most people don't. I'm one of the few that tries to, but most people don't. And so the only way that we're notified of any type of changes to the requirements is through our paperwork. And so if somebody gets complacent and, kind of breezes through them, they could miss that. I think that if with the registration stuff, not knowing whether my paperwork's been received, not knowing whether my paperwork's been mailed to me, not knowing whether I may have missed something, in terms of new rules. I mean, there's something as minor as that you need to take a picture on your birth month every year, right? It's a very simple requirement. I was not aware of that until I was on parole. And then on top of that, and this isn't a vilification of any agency or people, but each department has its own, each police department has its own rules as well. And so that creates some differences in opinions and procedures with how some things get done. So you're not only working with the BCA and the legislative rules, but you're also working with the police department rules. And anything as simple as me not getting my paperwork and me not being able to call and say, did my paperwork get sent to me this month, could cause me to be out of compliance. And if an officer deemed that I was, or an agency deemed that I had any reason to not fill that paperwork out, I could be charged. And then I would be back on parole. I would be back on conditional release. I'd be, if I was off or close to being done with my registration, which I'm lifetime, but for somebody else, I would be required to register again. So there's just a lot of consequences for what could be a mistake on somebody beyond my part, so.
Sheriff Heck.
Thank you. Sean, also, I'd like to thank you for sharing your story, and I appreciate the difficult climb you have every day to keep working at doing the right thing, and I applaud that. I just had a couple questions. first, you had mentioned as you were talking that you got a conviction for 3rd degree. Was that a 3rd degree criminal sex conduct?
Yes, sir. It was a statutory criminal.
Okay, very good. And then I'm kind of curious as to how this POR changed from being a list of offenders for law enforcement to use as a resource and to kind of morphed into what you're describing, which is more of it's a modern day scarlet letter that you have to wear. So you talked about housing. So the obstacles that you faced related to housing, were those more because of your status as a registrant, or were those more because of the fact that you had criminal convictions, or don't you know if there was a difference there?
I believe it's 50-50, sir. Part of it is the criminal conviction. I can't speak for other cities, but at least where I'm at, there's a large movement towards management companies building large buildings and or taking over private stuff. And so most rental companies won't take anybody in with a drug conviction, a sex offense, any type of a criminal conviction that could be of a felony status. And so that's one thing of it. But the other side of it is the ongoing issue with growing ordinances. In my city, I've went as far as to try and fight that and to advocate in my own city by myself. And I've gone as far as speaking with council members, advocacy groups, the city attorney. And in my city, I was told by the city attorney that the laws were put in, the ordinances were put in not because of a specific case, but just because that lawmaker saw it in another city and was like, we want that, we need that here. And so if there's a city of 100,000 people that is about 6 miles wide, 7 miles wide by whatever, tall, if I can only live in 13 blocks, 14, 15 blocks of that, and a majority of that space is either, large property management or non-residential area, it's vacant, or businesses, then my level is severely limited. And then on top of that, you have to get over the public fear, because if a landlord takes me in and now somebody in the neighborhood finds out, that landlord is going to be chastised, bothered, harassed. Their building, maybe, there's so many different fears that go with renting to somebody. And so it's beyond just the fact that there's these restrictions for me. I have to get over the public opinion as well. So that just dwindles things down to so little options.
So one more question, then I'll let others get in. Are there any other instances in your life where you can specifically point to your status on the registry and say, this interfered with a major life function that I had that I'm having struggles with?
Businesses use the registry to put in policies not to hire people. An example would be Holiday Gas Station. I applied and was accepted and offered a job. They went through their HR, and it came back that they had a policy that they won't hire sex offenders. Anybody on the registry required to register, they won't hire. It's been similar with other jobs. The YMCA, they have a thing where anybody on the registry is not allowed there. So you cannot use their gym. Same with other gyms, big chains, Anytime Fitness, things like that. So it leaves registrants with the option to either not go to the gym or to just be quiet and keep it to themselves and try to just stay anonymous. It's a fear thing. Like you just, you don't want somebody to be harassed or to come in and then have other people leave, So they use that as a way to keep them out. Sorry, I have some things written down because I'm fairly nervous here, but the public housing issue, there's a federal thing that says anybody on a lifetime registration can't receive Section 8 or housing assistance. I'm currently on SSI for mental health issues. And I work as much as I can part-time. It's been really hard with COVID and with my conviction to find work, but I make barely enough to get by. And so I'm kind of limited, and I've been trying to find a better apartment, but I can't get housing help. I've had, and this is not me personally, but these are people that are close with me, I've had people be removed from charity functions that they help with yearly because somebody recognized them from a community notification or personal, just having seen them and known them and reported it, and they were removed because of public opinion. I've had people get removed from jobs because a patron came in and reported that they were on the registry, even though they had reported that their job and they were okay with it. The public outcry was caused them to be removed from work. There's the parental rights. There's the ability for me to not make new relationships at functions. I play a lot of softball, soccer, things like that. I choose not to get close to people because with the public notification, even though I'm a level 2 now, that stuff is always on the internet for the rest of my life. So if I play something and I get close with somebody, if they should choose to search me, I would most likely not be allowed in those recreational activities. So it's just a lot of living in fear. I'm just super glad that I was given the tools to deal with this on a daily basis by the people who did treatment with them, and that I have such a great support system, because without them, I probably would have failed. So it's just very stressful.
Thanks, Sean.
You're welcome. Thank you.
Patty.
Thank you, Sean. I really appreciate your honesty and the reality that you're having to live through, which is challenging. I'm going to ask a ridiculous question because this is what I hear from the general population, which you've already addressed, that there's challenges with the public opinion. But do you think in any way that being on a registry helped prevent you from causing sexual harm again?
No, and I had written something up, but I think it's just better to not read it. It comes more natural. But I think life has choices, and as somebody who was not accountable for my own choices because I blamed everybody else from the abuse I suffered, I had to learn through my treatment that everybody has an accountability in everything. Whether I do something that affects somebody else and they react, they still have an accountability on how they react. So I don't think that the registry stops me. Ordinances don't stop me. Not that I would ever do this or contemplate it, but an ordinance is meant for public safety. If I can't live next to a park, what stops me from living on the other side of the city and driving, walking, busing to the park? There's no, it's a thing used for fear. The public registry was supposed to be used for police to have an avenue to search down people they thought maybe involved in a crime. And so that evolved to putting me on TV. I would say, if anything, the registry has created situations for me where I've been more likely to commit a crime. Now, I haven't considered that, but risk factors, right? We talk about risk factors, warning signs, all these things. If my warning signs and my risk factors are being secretive, being depressed, not dealing with my mental health, not being active physically and socially, hiding myself away, which is what happens when my level 3 notification went out. I put myself at risk. If I need to be doing these physically and emotionally positive things, but I can't due to the registry, it creates a risk. If people have a need to feel accomplished in their life. If they don't, they put themselves at risk by, finding ways to meet that. So, I just think that the purpose has been misconstrued. I think that the need for public safety has taken us from public safety to fear driven. And it's become, it's become, how can we stop these monsters versus how can we balance putting them in a good position so they succeed versus making sure that, law enforcement has the proper information if something were to happen. And that's why I would really like to see the information on how the registry is really being used. Is there a purpose for it other than public notification at this point? Because if it's not being used to take people out of consideration for crimes, or to help police search people down who have committed a crime, then what is the purpose?
Yeah, thank you. I have one other really quick question. When you were 15 and first charged, did you receive sex offender treatment at that point?
This is not a knock on any treatment facility. This is just my experience. But I did. I was sent to programs. The first program I was at was it was a smaller program, and that program focused mostly on just being honest and then kind of like warning signs. As a juvenile, you don't really, as a 15-year-old kid who's struggling with mental health and struggling with self-esteem and all this other stuff, it didn't help to just sit there and be vilified and to talk about the things that I did versus getting the help, and then just to be like, oh, well, you just need to not do that. So then I went to another facility because I wasn't able to complete that. Sorry, I have a flyby. I wasn't able to complete that. And the next one was all about shame. And so I removed myself purposely from that program. And then I was able to finish the third one. But my treatment as a juvenile focused specifically around warning signs and around like just using support. There was no actual treatment being done to fix the issues that were causing the abuse that I was causing. So it was non-existent for me compared to what I got as an adult.
Thank you.
You're welcome. Thank you.
Angie, and before that, I just want to make note that if we want to reserve time for public comment, we're getting close, but the group can look at that.
I just have a quick question on the ordinance. Was your ordinance, as far as housing goes, related to you being a level 3 offender or being a registered offender?
It was for being a level 3. The level 2 and level 1 in this city don't have the same restriction. But level 3, if they're the most risk to reoffend, I'll be this. Okay, so I came to a piece in mind where I was being told I had 5 days before I was going to be sent back to prison, even though I was compliant with my parole. I had work. I was doing everything I was supposed to do at that time. I was being told I would be sent back because I didn't have housing, and my funding, my time in that house had run out because I needed the room for somebody else. If I was not able to find that house, at that time in my head, I did the correct thing and I used my support and I searched and kept going hard. But in my head, I had the option. Do I run? Do I go back to prison and hopefully they let me back out and I can redo this, because it took forever to get out of there. So I didn't want to go back, and I was angry and depressed. If a level 3 is the most risk, why do we continue to put them in situations where they're forced to make risky decisions? And so I don't think it matters. I mean, not being on the registry itself is an ordinance, because no person wants anybody that's a registrant in their neighborhood because of public fear. So the ordinance is bad in itself, but just being on the registry is kind of a social death sentence, I guess you could say.
And just from a
Representative,
group, I was just going to say, just from a group standpoint, that might be something for the collateral consequences to look at, is to do some kind of survey around the state of what the ordinances say with respect to registration and levels. And I know Representative O'Neill talked about that is something that the legislature could potentially act on. So.
and we do have that survey, and we can send that out to everybody on the 90 ordinances.
Okay.
Representative O'Neill.
Were you considered a level 3 or because of your failure to register, or because of what you were convicted of?
It was not specifically, as far as I can remember. I was given that in 2008. So 2008, I was given the level 3 status. If I remember correctly, it was because at that time I had not completed an adult facility treatment. I had been deemed with chemical dependency issues, which my chemical use has been very, very minimal in my life. It's mostly alcohol, and it was just when I was real young. But I was given that. It was because the victim was considered a stranger, even though Later on, I was told that it wouldn't be considered a stranger. There was no social system, no work history, things like that. So those were all things I improved upon for my level reduction. Although I will say that I do think when it comes to the level system, they do the best that they can. I feel like sometimes it is inconsistent, maybe not so much in my case in 2008, but those processes upgrade themselves throughout time. They become more reliable, more realistic, fact driven. So from 2008 to 2008 or 2022 now, where I've gotten my reduction, things had changed. And so I'm still be considered a level 3 in 2021 when the scoring may have given me a level 2. So I just think that it's really hard, and I'm just grateful to have gotten a level 2 and be able to move on from that a little bit.
Nicole.
Thank you. Thank you, Sean, for sharing your story. I think the biggest questions for me are, and not necessarily for you, Sean, but I think all of us need to think about, like, what is, the purpose of the registry? Is it working? Is it not working? What do we want from the registry? If we're looking, and I think we have to look at, there is a reason why there's, there's the public safety issue for the registry and needing to have that for whether certain employment issues or housing. There are cases where I think it is absolutely appropriate. And also then I think, the bigger issue, and Sean, to your case, is that how do people get off of the registry, right? This has been, most of your adult life, right? Since you were a teenager. And so the bigger issue is like, when people, work hard to try and change their lives, like how are we supporting that work as well? And not just continuing the harm of keeping someone, kind of like you talked about the scarlet letter, but how do we really, I hate the term reward, but how do we get people off the registry who are really doing the work to make change in their lives and to not reoffend? So we can support that, because that's really our ultimate goal, right? Is to not have any more victims and to not have people that are reoffending and committing these crimes in the first place. And so those are just some of the things that I was thinking of, Sean, as you were talking. And again, thank you for sharing your story.
So we're at the end here. We do want to give the opportunity to the public viewers to be recognized and make any comments that you would like. So if you are just an observer, this is the time that you can raise your hand and make a comment or a question. Give you that opportunity, and otherwise we're at the end of our time. Olivia, did you have any comments that you wanted to make before we close out the day?
No, I will plan on doing the research as soon as I can and get that out to you as soon as I can, folks. Otherwise, feel free to let me know if there are things that my research isn't addressing that you're needing, or things that you would like to see differently in things. So I'll be sure to get whatever I can for you.
Our chairs, anything last minute? Angie.
Are you gonna send out those ordinances?
Yes.
Mark?
Yes, and they will be posted also. And there is a description on them to show whether they apply to only level 3s or to a broader.
So good to know somebody already at work.
Yep.
Thanks. I have nothing else.
Anything? Okay. We'll wrap up. We'll have this recording available also, and we'll get some of those notes and minutes out there also. Get all these attachments and requests, both from that Olivia and I will be working on. So, Stacy.
Okay, thanks. I was trying to unmute myself, but you wouldn't unmute me, Mark. So I just want to say thanks to the people who presented today for sharing your stories and your perspective. We really appreciate the time that you've given and the thoughts that you've shared. And we will work hard in our subgroups to further flesh out the issues. And I want to just say thanks for everyone who's participated in the meeting today as we think through these really sensitive and difficult issues.
Yes, thanks, everyone.
Yeah, and the next subgroup meets 9 o'clock, bright and early Monday morning.
Thank you.
Bye. Bye.